Daf Ayin is sponsored in memory of Kayla Zelda Bas Avrom. As a consequence of Rabbi Yochanan's rule that one who is not in possession of what belongs to him, his ownership is impaired. And yesterday we said regarding consecrating or deconsecrating items, he has limited ability as a result of not being in possession of what is his. The Gemara today on Daf Ayin brings another legal consequence regarding executing a power of attorney. In other words, that if a person is not in possession of what belongs to him, he cannot execute a power of attorney. The first version in the Gemara, which is the opinion of the Nahardoim, their first opinion is that a power of attorney cannot be executed for movable property unless the owner is in possession of the disputed property in order to transfer ownership to his agent. It does not suffice for the attorney to be an agent representing the plaintiff. He must be a party to the suit. Otherwise, the defendant does not have to respond to a subpoena of a third party. If the custodian responds to the claim of the agent without power of attorney, and the property was lost by the agent, the custodian is responsible. Rashi claims that one cannot write a power of attorney even if the movable property is deposited by a custodian, what we call a pikadon. Although normally one can transfer a deposit, the Ketzois explains our case as exceptional because the custodian is not willing to release deposit until settling some other claim with the depositor. Tosfos, on the other hand, holds the rule applies only in reference to theft or a loan where the property or money is not available for transfer. The second version of the Nahardoim is that power of attorney cannot be executed only where the custodian denies the claim of the plaintiff. Since the power of attorney reads he is transferring property to the agent, and here the custodian denies the claim, therefore it appears that the witnesses that attest to this document are signing on a false document. However, if the custodian did not deny the claim, then the power of attorney can be written even though the plaintiff is not in possession of the property. The power of attorney appoints him as an agent to act on his behalf. The text of the power of attorney reads, "Sue the defendant and procure the proceeds for yourself." That entitles the agent to ownership. The defendant cannot dismiss him as a result as a third party. The Ramban adds that until the inability of the plaintiff to transfer ownership only entitles, this is according to the second opinion of the Nardoim, that the inability of the plaintiff to transfer ownership only entitles the original owner to retract until the power of attorney takes possession. Abaya holds, even if the plaintiff allotted the agent only part of the proceeds, he can represent him in court. There is a machlokas if the agent seizes the property for himself, is he permitted to keep it? Maimar says yes. He holds this is the consequence of the transfer. Rav Ashi, on the other hand, says Since the document includes that the plaintiff assumes responsibility for court expenses, he appoints him only as a shliach or a partner. These legal entities, however, are different. As an agent, he cannot seize any amount for himself. However, as a partner, he can seize up to half. The halacha is he is in fact a shliach. The next part of the Gemara discusses the principle of al pi shnei edim yakum davar. Al pi shnayim yakum davar. What does it mean that you substantiate a claim on the basis of two edim? What does the word davar in that verse include? According to Rabbi Akiva, he requires testimony to establish the matter fully. The Mishnah Daf Ayin says, even if there were two witnesses to a theft and two different witnesses to the slaughter or sale, the thief is liable for both for the kefel, for the theft, and for the 4 and 5 if he slaughters or sells. The Gemara attempts to prove that our Mishnah cannot follow the view of Rabbi Akiva. He holds that in order for one squatting on a field to establish his chazakah, his presumption of ownership, not only can there be no protest by a previous owner, the same witnesses must testify to all 3 years, otherwise it is not a testimony on a full matter. The reason being is that one set without the other cannot establish a chazakah. So too in our Mishnah, the thief would be exempt from 4 and 5 if the witnesses were different than those of the theft. Abaya reasons that this is not true. Certainly Rabbi Akiva would agree if 2 witnesses testify that they witnessed her marriage. A woman got married in Nisan. 2 witnesses witnessed the marriage. Even if a month later other witnesses testify she committed adultery, we would not exempt her from punishment because their testimony is based on the first testimony that she was a married woman. They, in fact, did not know that she was necessarily married. Therefore, and it can't be that Rabbi Akiva would hold that she's not punishable, therefore Rabbi Akiva defines a half matter only if one set does not establish some independent consequence. In our case, since the theft is established without the testimony of the sale or slaughter, it is not categorized as a half matter. The Mishnah's second law is that if the thief stole the animal and sold it on Shabbos, he pays a 4 or 5 payment. The Gemara brings a brisa that claims he is exempt for the sale on Shabbos. The Gemara explains, which is a contradiction. Our Mishnah says he's chayiv to pay the 4 and 5. There's a brisa that says he's pater. The Gemara explains the ruling of the brisa is based on kamlei b'derabba minei. Since the buyer instructed the thief to transfer the stolen animal by way of cutting a fig off his tree as payment. So therefore, the cutting of the fig and the transfer happened simultaneously. So he's liable for cutting the fig on Shabbos and exempt from payment. The Gemara wonders how this could be a legal sale, since the buyer could not force the thief to consummate the transaction, either by providing him the animal or return the fig. It is therefore as if the thief received nothing. Reb Papa therefore explains that the buyer acquired the animal. The case that we're talking about in the Mishnah, that he's chayav 4 and 5, is only by way of a kinyan chatzir. As soon as the animal enters the airspace of the courtyard, the buyer acquires. However, at the time the thief violated the Shabbos prohibition to transfer from one domain to another, according to Rabbi Akiva, who holds kluta kamisha hun chadami, unless stipulated that the kinyan does not go into effect until the animal is placed on the ground, the brisa would be following Rabbi Akiva's view that simultaneity takes place based on the animal entering the airspace of the courtyard. And that it would be according to Rabbi Akiva that he would be patur from paying dalet and hay. According to the Chachamim, it would only be a patur if he stipulated that the acquisition does not take place until it's placed on the ground. Rava, however, explains the first answer of cutting the fig for the seller's payment also is valid. He proves this from the case of Esnan Zona. If a son propositions his mother, she cannot sue him in court for a fee because he is liable to the death penalty. However, the fee is not considered a gift. She cannot bring it to the temple.